All right. Well, we have 3 2/3 groups of 3. And our first one is Will Bode, Judd Campbell, and Steve Sachs.
Great. So I, of course, welcome the legal turn, and I'm happy to be a part of it if it'll have me. But I would be curious. So somebody came up to us after our paper and asked what we gain by calling the legal interpretive rules law as opposed to something else. And so I thought I would turn the question and ask, what is gained by calling the legal interpretive rules language for you guys? And in particular, does it work like other languages? So if we read the various sources on sort of what makes a language shared or what kinds of practices it takes to make language, will they be the same? Or will sort of this language work differently than the languages we're familiar with? So just the example I thought of is, if there were a legal interpretive rule that everybody forgot about. For example, I think somebody points this out in a recent article. There are some legal interpretive rules in the U.S. Code or in the statutes at large that they forgot to put in the U.S. Code. So they're unquestionably law. They were enacted. They're passed. They're sitting around, but nobody remembers they're there until somebody sort of digs them up. Do those count too as part of the language of the law? Because if so, I think then there's sort of no daylight between thinking of it as the law of language or the language of the law. We could just flip it whichever way we want. But if those are different, that'd be helpful to know.
Yeah, so I just wanted to kind of make a point that builds on Chris's point. And so I see the 5149 as being kind of an evidentiary threshold as opposed to an interpretive rule for resolving two conflicting principles. So on page 61, you say, assuming there was a background meta-interpretive rule to apply to the established interpretive rules. And I'm wondering 2 questions. First is, what if there wasn't? So that's an assumption. What follows if there wasn't? And then the second is, well, what might that meta rule have been? The only thing that I can think of is that the meta rule is, as James Wilson said, the first law of government, which was the happiness of society, which was the general welfare, the common good. And the problem here is that there's a vast amount of indeterminacy about that concept, about what the common good even means, and then once we decide what it means, then how do we actually flesh it out? It could be also argued about, well, at what level of specificity do we have to evaluate the common good? And so I think the general answer for the founders is that rather than having extraordinarily detailed philosophical arguments about that set of questions, the more important issue is who gets to decide what's in the common good. And the key decision-making bodies are representative institutions. And so I wonder where there is a lack of clarity, whether that leads us to a form of popular constitutionalism, assuming that the meta rule is something like the common good.
So I have 2 points. The first is on the interpretive intent, semantic intent sort of distinction. I thought that I appreciate the turn to interpretive intent. I thought the direction that you were going to go in was something more like the position in Richard Ekins' book, which is that in some ways is necessarily true. So this is the point I thought Chris Green would this is the Chris Green modality point. Ekins' claim is that it's necessarily true that what we care about is interpretive intent, because what it is to vote in a multi-member legislative body just is to participate in this practice where you share a joint standing intention to change the law when necessary, and the way you do that is by occasionally manifesting more specific intention to adopt a particular open proposal that's on the table by raising your hand yes. And that sort of what you intend when you vote yes is that that proposal be adopted, just like when you punch the card for a particular presidential candidate, you are intending that they become the candidate, and whatever other motives you have are sort of irrelevant to that. And so, of course, you're saying we should adopt this proposal subject to all the prevailing legal rules that might then say what happens to it afterwards. I took your argument as being slightly different. It was more of a contingent argument that, as a matter of fact, people care more about the correct interpretive rules being applied than they care about the particular norms they had in mind being showing up in the law afterwards. And in case they're getting the interpretive rules wrong, they want the interpretive rules to apply and not the particular norms that they have in mind. That may very well be true. I just wanted to make clear that A, you're picking the contingent approach, and B, sort of that you really do prefer that to sort of necessary argument. Second point I wanted to make very quickly, following up on Will and sort of law versus language. Again, it doesn't really matter so long as the substance is the same, what the labels are. But one thing that using the labels differently might help with is to clarify certain kinds of questions. So for instance, what do we do if what the lawyers say at the founding is different than what they actually do at the founding? It might be relevant on different theories of jurisprudence. Like, those are both sociological practices. One is the practice of doing X, and the other is the practice of saying X. And your jurisprudence might tell you which one wins. But I don't know very much about philosophy of language that would tell you which one wins. Or at least it would seem very weird that there would be languages that would care more about what we say about them than how we actually speak them. And maybe you could use language as a term that way. It would just seem like more of a stretch. And so I guess what I'm wondering is, when would jurisprudential disagreements make differences for you as opposed to the kind of disagreements that go into like ordinary language dialect disagreements?
So you're correct that the argument we make in the paper is a contingent argument, I think the necessary argument seems a bit strong. I can imagine a legislature of Larry Alexander's, intending their substantive matters. So I don't really see the necessary argument. It's more of the contingent one. On the question about the jurisprudence, it's a tricky sort of overlap here between the two positions, because the language of the law obviously makes reference to the legal interpretive rules, which were the rules at the time, the law rules at the time. So there's really quite a bit of overlap there, and I'm not sure then that if that was the law at the time, that it wouldn't also influence how we would read the language of the law, right? So it's an interesting question, sort of how the two come apart. Which leads to sort of Will's point about what if they forgot. Now, I try to take these positions and take them out of the context of the statutory area, because that you guys want to make a claim about that, and we're not making a claim about the statutory area. Maybe the same language, the same rules and approach end up resulting. So so you don't really have a legislative enactment at the time of the Constitution that his example seems to appeal to, that's doing the work there. If you had a background legal interpretive rule that had been forgotten about, that was, you might actually say it's not part of the general law at that time, and it would no longer be part of the language of the law. It used to be in the language of the law. It's now not part of the language of the law. So again, the two go off in very much the same direction.
I guess just to say a few words again about Judd's comment on the 5149 rule. I think it may depend on where we think about, where we put in the idea of general welfare into the Constitution. My own thought, generally, we're going to see it in some substantive take on the Constitution. That's why the duty of clarity, assuming it exists, comes from the nature of judicial power, which is a nature of the relation of branches to another. When we don't have that kind of argument, I think the 5149 rule is not a natural rule. Moreover, it seems to be the rule we observe. We don't see anyone when we look at them debating about whether this is an interpretive rule, whether this is the actual language, whether this is the word meaning, we don't see them saying, well, we're going to put some thumb on the scale about that interpretation. Sometimes I think there is a thumb on the scale, and Mike and I may disagree about that, whether we're going to displace the other branches. We certainly don't see any argument, though, about the duty of clarity or about where we should put the thumb on the scale when there's interpretation in Congress. The people are talking about interpretive rules often through the time, and they're arguing about which is the better interpretive rule. And at least I've not seen it, and we certainly, I've not exhausted this, but I've seen no evidence that people said that there's some particular thumb on the scale in some particular area. And I think that might be the, because that's the first interpretation, that might be the area that you might want to look for it to see if there's some peculiar rules, some peculiar evidentiary standards that are different from the normal evidentiary standards to find interpretive rules.
The other point, I may have been misunderstanding your point, but I don't see any evidence for a claim that there was an interpretive rule to follow the good of the people, and I don't even necessarily think of that as an interpretive rule. So that would be what I would say in response to. I may have misunderstood you, claiming that was an interpretive rule, but if that was the claim, I don't see any evidence at all for it, or even it's hard for me to imagine it as an interpretive rule. Whatever will be the good of the people.
All right, our next group is Larry Solon, Michael Mcconnell, and Guy Burnett.
So, wonderful paper. I really appreciate the ecumenical spirit of the paper, that you look for convergences. And to the extent that there are disagreements, I think that there's a wonderful process of dialectical development of these ideas. And I certainly look forward to responding to the ideas in this paper, and I think our positions converge in many ways. So I just want to thank you for the paper. It's very helpful. I have just a sort of a point of personal privilege. So I don't call my view constructionist originalism. I think using a label like this to name another person's view is somewhat problematic. I don't think you would like to be called the legalese originalists. And maybe you could call my view and Randy's view what we call it, which is public meaning originalism, and then disagree with the particular theses that separate us. So with that plea out of the way, on the part of the paper that advances the language of the law hypothesis, right? So just a tiny minor point on that. The language of the law will be a natural language, right? The fact that it's spoken by lawyers does not take it out of the category of natural language. That label refers to all languages that human beings speak. And also minor on this, I think it's really helpful to do what Chris Green suggested and look at Hilary Putnam's work on the linguistic division of labor. So I just want to suggest that some precision, this is a genuine suggestion. I think it makes your position stronger. The way you frame the language of the law hypothesis is somewhat ambiguous, and it could be understood in a way that I think is not helpful to you. That is, that there are two distinct languages, English and legalese, right? Legalese is like law French. It's an entirely different language spoken by lawyers. It just happens to superficially resemble English. It's got lots of common words, right? That is not the position you want to take. That's a radically implausible position about the way that lawyers communicate. So you want the position that technical legal language is a superset of ordinary English. It also includes areas where terms in ordinary English that are unambiguous have other senses that are introduced in the legal use of the term. So getting all of that fleshed out, I just think it's going to make your story more persuasive, more plausible. That story is right. And of course, it applies to the Constitution because the Constitution includes, as you point out, and I have a research assistant coding the Constitution word by word, it includes a number of technical words and phrases and words that in context are obviously technical, although acontextually are not necessarily technical legal terms. So I just think that that will make the paper, that the language of law hypothesis more plausible. At the part of the paper on page 20 where you employ the Gricean framework, again, this is a suggestion for how you can make your position stronger. It seems to me that it's absolutely true that the Constitution can communicate to the public, but that the public can be made aware that in particular places the constitutional text employs words that are technical, that is, that the technical meanings, the language of the law meanings sort of announce themselves, and then, you know, you ask a lawyer, what is a letter of marque and reprisal? I've never heard of this, right? And that's absolutely common ground between us. But I think that the test case for you, and I just think emphasizing this will make the paper clear, are the cases where constitutional language appears on the surface to be ordinary English, but where in your theory it turns out that the ordinary meaning, the public meaning, is not the meaning of the Constitution. And that's sort of the test, those are the test cases. Those are the cases where your theory is different, and sort of zeroing in on those test cases would be helpful. One last suggestion, again, ways in which the paper can be made stronger, and this is something I have struggled with. So when you're talking about forms of underdeterminacy, I think it's really helpful not just to distinguish ambiguity and vagueness, that's a very important distinction, but also to take a look at other forms of underdeterminacy. In legal theory discourse, there's a lot of talk about open texture. Open texture and vagueness are two different phenomena, and unpacking open texture is a whole thing. I won't say anything about it. It's just, it's not the same thing as vagueness. And then there's a particular problem, not much talked about in the law, but very important because some of the concepts in the Constitution, at least to me, look like they are this kind of concept. These are multi-criterial concepts with incommensurable dimensions, and reasonableness, the word reasonable and or at least unreasonable, is in the Constitution, and it looks like it is a multi-criteria concept with multiple dimensions. That gives rise to a different form of underdeterminacy. I just think it's a wonderful paper, and I'm genuinely offering ways that the paper might be made stronger. I will have some answers to this paper in due course, but I think there's lots of ways in which the paper has really moved the ball forward, and it can move it even further forward.
Michael.
Like Wilbode and others, I appreciate the turn to an emphasis on the language of the law. This seems to me very helpful. It's actually language that speaks to me more helpfully than your original methods, originalism language. Even though now I understand that that they are at least closely congruent, but it makes more sense to me. But I do wonder how it relates to some of the other distinctions in new originalist theory. In particular, just to start, is how does it really relate to the emphasis upon original public meaning? Now, I don't mean that it's inconsistent with that, but it does seem to me that it puts the emphasis on somewhere other than the public, because the public doesn't actually speak in legal language, and yet the public will understand that when they see a document in legal language that it must mean something else other than this. And it just strikes me, not that this disproves that distinction, but it suggests to me that maybe the emphasis upon public meaning isn't so important and doesn't actually get us very far, that really what we ought to be focusing on is what the language does in the context of their time. And when we see legal language, that's a clue. But in general, when we look at the Constitution and we see odd phrases and odd ideas, the best thing to do is to ask sort of, where does the language come from? Maybe it comes from law, in which case legal language, but maybe it comes from British parliamentary history, in which case we might want to look there. Maybe it comes from something else, particular episodes and that the framers were well aware of. All of this strikes me as not necessarily, it seems to me it's backward focused and not public focused, and makes me think that a lot of the discussion of like big data on how people use language on the streets and the pubs in 1789 was very unlikely to be helpful, not because it's theoretically unhelpful, but just because in practice it's not going to tell us a whole lot about the language of the Constitution. And in particular, I don't understand, I guess it seems to me, my intuition about the proper interpretive method, and I don't know what label to hang on this, but it seems to me that the language primarily means what it has to mean in order to accomplish what we know that they wanted to accomplish when we know what they wanted to accomplish, and sometimes we do and sometimes we don't, that it's purposive language, and this is not subjective intent. I don't really think it's that it's original intent in that sense. But I think it's a theory of meaning, but people use words for a reason, and I think the legal language emphasis is a subset of that. But in general, all this makes me think that two of the sort of uber distinctions in New Originalism, that is, it must be public meaning and it must be meaning rather than intent, actually don't get us very far. And what we need to be thinking about more is what does language do, and what was it thought to do then, and that requires more history than it does philosophy of language. And so maybe we ought to be talking more history than linguistic philosophy.
John.
Okay, so I'll start and display my lawyerly ability for this original methods code. I dissent and concur with both, with some of the things that have been said already. I thought the paper was incredibly useful, and it was very, very helpful, and I think this new sort of focus is just wonderful. It's something I'd never thought about, and it's something, though, that I think the only thing that disturbs me is the dismissal of intent. It seems to be, is that it's not as much focused on. And let me start off by saying that I was unconvinced about Marshall when you brought up and said that it was shown that Marshall used these things, and he definitely was not a plain language guy. But both in McCulloch, where he says, right, it can't contain the prolixity of a legal code, and et cetera, it has to be, if the public doesn't understand this, probably never be understood by the public. And then in 1819, he says, in his Friend of the Union, where he's talking to Spencer Roane, he says, quote, "The words of an instrument, unless there be some sinister design which shuns the light, will always represent the intention of those who frame it." And it seems to be that he is one of those intentionalists, right? And not in the sense of there is a special way of writing this, but the public understood this is a public document. It's not a hidden one. Which leads me to a bigger point about the sort of understanding sort of for lack of a better word, legalese, legal code of the Constitution, about creating a too powerful judiciary. And I know you just sort of answered that a little bit, Michael, about you don't see that, but the only thing I worry about is in the convention, when we have John Dickinson brings up, the interpreter, right, the justiciary of Aragon becomes by degrees the lawgiver. So if they're the only ones who can tell you the correct way, right, if they're the only ones who can correctly interpret this legal language, these either lawyers of the Supreme Court, does that make them regnant, right? Does that make them the most powerful? Are they the best? So instead of looking at the founders and the principles that are embodied there, the Declaration, natural law, things like this, we look to subconscious legal words they used and 15th century texts. And I think that's very useful when there's gaps, but I think to supplant any kind of understanding of principle or values in the Constitution, I think is dangerous. And I see this as something where if we use intent as a lighthouse, if we don't use it sort of that way, the ship is adrift. If we're sort of straining at a gnat to swallow a camel. And so I was wondering more if maybe it wouldn't benefit a little bit more if that was sort of fleshed out, that intent is much more important. And then in these gaps, there's sort of, we can use this method. And maybe that is written well enough, but maybe I just didn't catch that. So.
Back to you.
Okay.
Sorry, go on.
Something to say about Mike McConnell's comments about, I still think we are public meaning originalists. I certainly think we're within that family of originalists. And the points I think I would stress, while sort of accepting much of what you have said, is, first of all, I think largely the legal meaning is in some sense continuous with the public meaning. Most of it is sort of precisification of it, or secondly, it's there's this division of labor that Chris Green talked about. People explained what the legal terms were in the debates. Moreover, it's publicly available meaning. You can go back, as you exactly said, to the history to figure out what these terms meant. So in that sense, it's public originalism. It doesn't depend on the intentions of the framers that may have been secret at the time. So I still think that we are within that public, and I still think that is therefore a useful term. With respect to purpose, I think I might turn it around. It's that in certain cases, the language of the law suggests we should look to the purposes of statute, and it's not surprising that it does that. The law is something that is to achieve human purposes, and it's not surprising, therefore, that we have interpretive rules that point to those purposes. So I certainly accept that our take on public meaning originalism gives us an absolute window why we would look at rich legal histories. Indeed, some of our examples certainly from the state constitutions about why they go back and look at British history show why the precedential nature and the historical nature of law is emphasized by understanding the Constitution in the language of the law. I'd still be cautious. I'd still like to see ourselves, though, as within the public meaning. I think that move to public meaning, as opposed to the intents that might not have been publicly available, was still an important move on which this builds, even if it somewhat complexifies what the public means in public meaning.
Chris, do you want to jump in? Sorry, Mike. Were you going to say something? I thought you were waving.
I was just trying to figure out if there was anything I wanted to add to that, and I don't think there was. I was going to say very much the same. Larry, thank you so much for those comments. They're helpful. I think we agree and tried to make clear, but I'm sure we can make it a lot clearer that the case of where the language has two meanings. One is a ordinary meaning and one is a legal meaning. It is an important test case for our different views, and we'll try to make clearer that and try to argue why we think the legal view matters here. But thank you very much for all those helpful comments. Did you want to take the Marshall point?
You want to? I mean,
Well,
talk to McConnell.
Okay. So we discussed that Marshall statement about, and in the context of the paper, what we think is going on there is he's responding to Jefferson, and to Jefferson and that position, which basically says you don't look at the language in any natural way that you would. People use the language so we think he's contrasting. He's contrasting a sort of unnatural use of the language. And he's saying people who don't have anything to conceal will use it in a natural way. We don't actually think that what he's doing is saying it's the ordinary meaning necessarily. And in addition, for the reason that we mentioned, that he throughout used lots of legal interpretive rules that if he believed that, he would have been, very inconsistent.
I interpreted the questions, or at least, and additionally in this respect, that the question was Marshall an intentionalist? And I think we think that Marshall is, or at least my best understanding, Marshall is an intentionalist in the sense that he thinks that the words of the Constitution tend to capture the intent of the framers, and I don't think he's an intentionalist beyond that. And indeed, one which I cannot produce at the moment, he actually, I think, says that at one point.
Right. He says you would only depart from the literal language in cases where all mankind would unite immediately, saying that no one could have meant that. So that's the kind of exception that proves the rule.
Chris, do you want to jump in?
In terms of Judge McConnell's point that we want to look at history instead of philosophy of language because this is purposive, I mean, actually, Lewis's stuff on focal points, he stresses that what language is something that people use in order to accomplish their social life together, do what they're trying to do together. A focal point is an efficient way to do things together. So he's building on Schelling's stuff from game theory. I think it is important to go back to do historical philosophy of language, but just get our best theory about how language work, I think, has gotta be useful for understanding how language worked in the Constitution. But yeah, the historical philosophy of language is something I'm digging into a lot, and I'm finding lots of interesting stuff. So there's people anticipating the sense-reference distinction in the 17th century, the Port Royal logic that then gets used in textbooks that Madison is using at Princeton, which is kind of getting replicated in Federalist 37 pretty clearly. So there's just a historical influence of the philosophers of language, and then the later developments and clarifications of what people who are just spend a lot of time just thinking about language as such, I think are bound to be really, really helpful.
The one point I would add about that is I actually think that both are needed. To my way of understanding it, maybe it's a little bit much to call it philosophy of language, but the theory of meaning is important for telling us what to look to. And what the theory of meaning actually tells us a lot of the time is we ought to be looking to the history to figure out these answers. And so the two are not necessarily opposed, but actually contributing to one another in that way.
All right, our next.
May I just comment?
Sure.
This relates to the focus on public meaning, because insofar as we're looking historically, it's not really about what the public is thinking. It's about what brought these ideas and these words and this language into the Constitution. I don't think it contradicts the public meaning. It just means that, the fact that it's public is really not that important.
But if I may, because John said this before, but I don't think of public meaning as meaning what the public thinks. I think public is a contrast with the private meaning, or the mental meaning, or the subjective meaning. So public meaning is just what's publicly available. And then the question is, when you're figuring out what's publicly available, the legal meaning would be publicly available, as would the ordinary meaning would be publicly available. And then you're going to try to figure out which of those two you would look to. But actually, part of what we try to do in this paper is to try to decouple the idea that public meaning is the ordinary meaning. Public is what's publicly available.
I think Lewis is really helpful here because precisely because of the move from what we know literally and actually have beliefs about, which if you demand then gets this infinite rigorous problem. He moves from that to what we're in a position to know, and the public were in a position to know all kinds of stuff if they would take the time to look up their Blackstone and yada yada yada.
All right, our next group, and we're getting a little tight on time, so bear that in mind. Our next group is Jamal Green, Kurt Lash, and John Harrison. Jamal.
So two related questions that kind of echo Larry's question about hard cases. And the question is, this question of whether you understand the document to have been, to reflect legal or popular understandings, whether you understand your burden to show that the Constitution as a whole reflects legal language, and then particular provisions just follow from your conclusion about that, or whether it's to show that particular provisions, whatever's under review in any given case, reflects legal versus popular language. I would think the latter, but I'm not sure what your answer is. And if we're talking about particular provisions, then I agree with Larry that methodologically, you'd want to show us the hard cases and work through them. And Mike, in answering that, it sounded like you were sort of pre-committed to saying that the hard cases will reflect legal language, and it seems to me that if that's the method, we need to work it out and work it through. The related question is, I assume it's the case that with respect to whatever your answer to the first question, with respect to later enacted provisions, you have to do the exercise again to figure out what's going on at the time of amendment. It seems to me at least not obvious that the conclusions you reach in this paper would apply as a general matter or as a presumption to amendments, which have a kind of plebiscitarian quality where there's a particular problem to be addressed, there's a solution is proposed, it's debated in the public in a way that's not quite true about the foundational document where there are secret meetings to come up with the initial text. That your instincts might be different, or one's initial assumption might be different as to a specific amendment. So,
by the way, I think it's okay to call Larry and Randy constructionists if we can call you Methodists. Okay, so I think that actually that could work. You talked about how the Constitution was born into this world with available rules of construction, and that might be true. And I like your project, and I support your project, but you know that I have particular historical concerns about it, because I'm not sure that it's true there were any available rules of construction available at the time of the Constitution, and I think choosing rules of interpretation in this case involved making a normative choice, and because you had, choosing your rule of interpretation involved choosing, resolving a dispute about the nature of the Constitution, and how you resolved this dispute about the nature of the Constitution led to this spin-off of very different schools of interpretive methods. For example, in this dispute you talk about Marshall, and Marshall defending his natural language approach. You notice he's responding to another school of interpretation that comes from St. George Tucker. And St. George Tucker's proposition was the Constitution was something new under the sun, and therefore earlier rules of interpretation simply did not apply. That this was an amalgam of both national and federal sovereignties, that their relationships with one another in agreeing and ratifying this draft created something that required negotiation of delegated powers in a way that wouldn't be true if you were just interpreting a single constitution of a single government. This was a compound government. And it had never been seen before. This was a new contribution to political science. Now, Marshall didn't like that approach, right? So in McCulloch, he begins McCulloch by saying we need to get around this idea that the Constitution was created by the states. It wasn't. It was created by the people, a single national people. Therefore, it can be interpreted the same as any other document created by a single national people. Story then writes his commentaries, supporting Marshall's view, saying we should get rid of compact theory and should support a rule of interpretation that we can take right off the shelf. We can just take this right off the shelf because we've been interpreting legal documents for centuries all the way back to Blackstone. And none of them call for strict construction, right? But you have a competing school of interpretation that leads to radically different rules of interpretation. And those rules came into being at the same time as the Constitution. There was nothing to be pulled off the shelf. So I guess my question is, does it affect your theory if there were no available rules? Does it affect your theory if Tucker was right, this really was something new under the sun that needed its own unique interpretive approach?
John Harrison. There is sort of a way to test this idea. Krosky said that the Constitution was much more determinate and a little bit different than some people thought it was, because it was drafted against the background of a series of 18th century drafting conventions and with some technical 18th century terminology that made it much more determinate. So it would be really interesting for you to have a chapter in which you engage with Krosky and find out, was he right, which would have interesting implications, and if so, how did he go wrong? Is the problem that it's actually harder to identify the drafting conventions than you might think, or that the conventions are less determinate than you might think? So do you agree with Krosky or not?
All right, you guys got about 2 minutes.
Yeah, no, that's interesting you mentioned Krosky, because when I first started thinking about these matters at the Office of Legal Counsel and started arguing, thinking that the original interpretive rules were applicable, I had read Krosky and seen the 18th century, and the short answer is, like everything else, Krosky's claims about what the history are very different than what the history ends up being. In response to Jamal, I think the position is a bit more sort of nuanced. So what I would say is that you look at the Constitution and you see through the collection of evidence that we have about the terms, the calling itself a legal document, the interpretive rules that seem to be referenced, it is a legal document. That says that we're operating in a world of the language of the law. Now, one of the interpretive rules of the language of the law is not that you always follow the legal interpretive rule, the legal meaning of something. In fact, it's probably one of the interpretive rules of the language of the law that you often follow the ordinary meaning. But whether you follow the ordinary meaning or the legal meaning in that ambiguous situation is determined by the legal interpretive rules, right? So you're within a legal document, you're applying those rules, but oftentimes that's going to lead you to end up applying the ordinary rules, depending on how you would resolve the ambiguity.
To Kurt's point, we certainly, as we say in the paper, we think it is plausible that there could be distinctive legal rules that we could infer from the Constitution. So it's certainly conceivable that St. George Tucker is right. That's again a question of evidence. Of course, Marshall not only has arguments about why Blackstone should apply, but why this is not a right inference from the Constitution. And so that's a matter of constitutional interpretation and inference, and one can't escape those kinds of questions. But I don't think that undermines the argument that when you cannot make an argument from that the Constitution is distinctively different from a legal document, that the body of legal rules generally do apply. So I don't want to rule St. George Tucker out of order, although I personally don't think he's correct, and that's a matter of looking at the Constitution and weighing the evidence from that.
All right, well, we are out of time, although people remain on the queue, but you'll have to take things up privately. Thanks very much.